We've talked already about, I think, WorkSafe's view around the utility of prosecution and the circumstances in which we use it. The purpose of this item is just basically to flag with you that, yes, the Model Work Health and Safety Act does contain provisions which allow regulators to enforce and prosecute. As Barry observed, and I'm pleased to advise this audience, many of those provisions actually are mirrored on what we already have in Victoria. So our Victorian audience, there isn't going to be much that's new, which I think is a good news story, because in terms of what we have to do over the next 18 months, the last thing you want to be doing, if you can avoid it, is to be getting to grips with a whole new regime. Essentially though, and as the slide indicates, an inspector is entitled to enter a workplace, any workplace they reasonably suspect to be a workplace, and that's particularly important, I suppose, for this sector in the context of people undertaking work at a place of residence, at a home. In circumstances where that place of residence is a workplace, the inspector would be able to enter it if they reasonably suspect it to be a workplace. Our practice, I can hear a certain amount of consternation about that. That surprises me, because you would know or may know that our practice is, through our inspectorate has been to give notice in the event we intend coming in to private residences which are otherwise used as workplaces. That is not going to change. All right, so you're not going to have the nasty person, or actually they're actually a great bunch to be quite frank, but you're not going to have our inspectors coming in basically and trying to knock your door down at 6 o'clock when you're watching the evening news, or rather your carers are not going to, simply because they are otherwise foster carers as well. Our administrative practices, our practice as a regulator has been to give notice in those circumstances unless there is a very good reason not to. And I'm sure we can all come up with scenarios where there would be a good reason not to. An inspector is entitled to issue improvement notices, prohibition notices or non-disturbance notices, as is currently the case in Victoria. They're also, and I must admit I'm not sure why this isn't on the slide, that's my fault, inspectors will also be entitled to impose infringement notices under the Work Health and Safety Act. Now, that is a concept which we are not familiar with in Victoria yet. But as of 1 January 2012, and the model laws become law in Victoria, an inspector will be entitled to impose what is otherwise known as an on-the-spot fine. Now, you're entitled to ask me, and I cannot yet give you an answer, for what offences will the inspector be putting or potentially putting on infringement notices? The reason why I cannot give you an answer is because that is the subject of work and policy development at a national level, so that wherever infringement notices are applied in Australia, they will be applied consistently. Victoria's perspective on this is that infringement notices should only be imposed for breaches which are observable, black and white, and which are offences other than breaches of the safety duties, which are the general duties under the Act. One of our concerns, our being WorkSafe Victoria and the Victorian Government's concerns, is to ensure that if there is to be an infringement notice regime applied nationally, and there will be under law, that it be applied consistently and appropriately across industry, rather than being used as, if you like, the stick with which to beat certain sectors of the economy. So that's that breaking news story, I suppose, as much as anything else. We see a great deal of utility in the enforceable undertakings regime, which we have in Victoria and which they've had in Queensland for an even longer period of time. It gives us the ability, in circumstances which do not involve a particularly serious offence under the Work Health and Safety Act, which we'll come to shortly, to enter into an agreement with a potential defendant, which essentially compels them to do things or to pay for things in order to improve health and safety outcomes, either within their workplace or within the sector in which they're working. We found them to be a great tool for improving health and, well, we think they're a great tool for improving health and safety without going through the rigmarole of a trial. Okay? Mindful of the fact, an inspector can also request the production of information held at multiple locations, and that's something to be mindful of as well. So particularly where you're operating multi-site workplaces, an inspector may be asking you for information, to produce information held at a location other than where you're at the moment, and you're required to provide it on reasonable notice. A number of you who are working in organisations which are multi-state organisations will rightfully have a query as to how we're going to actually make this work consistently in terms of the compliance, enforcement and administration of the laws across Australia. Certainly from WorkSafe Victoria's point of view, our vision, well in fact forget about visions, our goal and what we have to get to is that the experience of inspectors, the experience of duty holders of our inspectors, whether they be operating in Cairns, Canberra, Camberwell or wherever, throughout Australia, has to be pretty consistent across Australia. Because what we don't want is inspectors essentially feeling compelled to go into workplaces for reason X in one state and going into workplaces for reason Y in another, and producing an inconsistent approach to compliance and enforcement. So what are we doing about it? Well, what we're doing about it is Victoria is taking the lead in developing a national compliance and enforcement policy, which is essentially aimed at achieving that consistent approach I've been talking about. That our